Hi there, students. In today's comparative pollution laws lecture, I wish to discuss about comparative water law. And when it comes to comparative water law, I picked the country which ranked pretty good. In fact, it's the best, one of the best countries as per the Environment Performance Index of 2018. Guess which country? Switzerland. Switzerland, which topped the EPI of 2018, and it is, as you all know, one of the very smallest countries located in Western Europe. Everyone wish to visit that place. When it comes to Switzerland, the surface waters, the lakes, the rivers, and the glaciers, they are regarded as public water. In fact, as per this, the Banning Journal that I was referring, an article by Emily Ott, Sustainable Switzerland, the water policy to conserve and protect. It was very nice things that I came across. In fact, when it comes to Switzerland, which, as you all know, is not a part of European Union, despite being not part of European Union, it's been doing quite great when it comes to banking, when it comes to even environment. It is the federal government which is responsible for overseeing the protection of Swiss waters. There are individual laws. There are also policies specifically with respect to water. The most pressing water problem in Switzerland is basically the non-source point, surface water, and the fact is that as a result of this inevitable runoff water, the Swiss they usually need to be more careful of about the farming practices that basically put the water in danger. Now, in order to conserve the integrity of the public water, the private farmers they have been also kind of given certain incentives to alter their farming practices to avoid nitrate pollution. Well, when it comes to our country, we can learn something from Switzerland, especially with respect to incentivizing the farmers to switch to something which doesn't need fertilizers and avoid this nitrate pollution. Now, the thing is that when it comes to sustainability of the water law that they have, the thing is that irrespective of all the other facts which you will come across with respect to their performances, even it has been compared to that of European Union. The thing is that in the practices, the directive that is there under European Union, it is a fact that 90% of Switzerland's around 65,000 kilometer long network of rivers and streams have been straightened, have been dammed, canalized, and in fact channeled underground. So the water infrastructure with respect to disaster prevention, water management, they are working quite efficiently. In fact, in Switzerland, 80% of all the drinking water comes from groundwater springs, and it is generally of good quality. When it comes to the non-point sources, that is a problem which they are facing, and that's why they are trying to incentivize the farmers. There are water policies which have been also adopted by the federal government from time to time, especially with respect to water. They have individual policies. Like, for example, they have the Swiss Civil Code, which in fact gives the Swiss citizens their right to some free use of public surface waters. However, the state is the one which possesses the authority to interfere with these canton water policy, which usually come under the premise that all the flowing waters are termed as common property. However, these underground water sources are generally considered as private property, especially to those owners of the land in which this water sources resides on. But the limitations are that in place to protect the downstream neighbor as well as the general public and community, certain safeguard measures are required. Now, the thing is that, which in fact, we should also know that in general, these local authorities or the cantons that they have, the cantonments, they are responsible for water management, and very few of them reflect the boundaries of regional or local waters catchment areas. So the criteria for definition of management units are actually based on political administrative structures uh, instead of natural boundaries of river basin. It's a fair criticism that has been pointed out by some scholars, including the one that I referred. The thing is that the most pressing problem of Switzerland is non-point sources, right? Now, the thing is that when it comes to Switzerland, they are known for their incredible self-sufficiency in food production. The Swiss citizens are, were fed during the Second World War on locally grown food only. In fact, more than 63,000 farms in Switzerland they cultivate in an area of around 10,300 kilometers square, which covers around a quarter of total country's area. So, 25% of Switzerland's area is dedicated to farming. And when it comes to Swiss economy, the environment, the water management, it's very efficient. And it has a massive impact also on this water management with respect to agriculture. So, the thing is that when it comes to drinking water, there are some challenges which they are facing, and this is because of several such measures which they wish to take. Now, when it comes to the European Union, in fact, they have voiced some concerns with respect to European water pollution because a large portion of European fresh water comes from Swiss Alps. So the Rhine and the Rhone river basins, and at the same point of time, which begin from the Alps and it flows down to the neighboring European countries. So these transboundary rivers they contribute to the water flow of many major rivers like Danube, etc. So the shared water supply that European Union is currently, you know, engaged in, and the thing is that they're also pushing up for certain directives to reduce this nitrate pollution and preserve this drinking water quality. So this Commission on the European Union, also called the European Communities, they came up with this directive, commonly known as the Implementation of Council Directive. Their major concern was that this nitrate they react to the compounds in the stomach, which can be carcinogenic in nature. So they came up with this European Union Water Framework Directive, where they proposed this best model single system of water management in the management by river basin. So they are emphasizing that the water management should be not on the basis of administrative or political boundaries. It should rather be on the basis of natural, geographical, and hydrological unit. Well, since it's not part of EU, but still emphasis has been given, and Switzerland is something which has been also kind of, in a way, the European Union is trying to, convince the Switzerland to maintain this, to adopt something which reflects upon hydrological and natural geographical way of river basin management rather than political and administrative. So when it comes to the law that they have in their respective country, the Federal Constitution of Switzerland, the 1953, it ensures protection of water bodies. And at the same point of time, they have also emphasized upon responsibility on all Swiss citizens. Uh, and here, these problems have also been addressed in a law which is also known as the Federal Act on the Protection of Waters. Now, the Water Protection Act that they have, it basically aim to protect the waters against harmful effects. It preserve the another. These are the some of the objectives which has been clearly envisaged and enshrined under the Federal Act on the Protection of Waters. Primarily, it aims to preserve the health of the people, animals, and plants. It also aims to preserve the natural habitats of indigenous fauna and flora. It aims to preserve water suitable as habitat for fish, preserve water as an element of landscape, ensure the irrigation of agricultural land, permit the use of waters for leisure purposes, and also to ensure natural functioning of the hydrological cycle. If you look into the legislation that they have, it has been very nicely divided into several facets. First factor is, of course, the duty of care. Then comes the polluter pays principle, and there are certain important definitions part also. As per Article 3, everyone is required to take all the care due in the circumstances to avoid any harmful effects of water. It's a duty of care. Article 3A emphasizes very clearly polluter pays principle, which clearly envisages that anyone who causes measures to be taken under this act must bear the cost. In simple term, anyone who causes measures to be taken under this act must bear the cost. When it comes to definitions, surface water has been defined as those water bodies and their beds with an inclusive definition, the bottoms and the banks together with flora and fauna living in there. So, flora and fauna has also been covered within the definition of surface waters. When it comes to underground water, it has been defined as groundwater. Even the spring water has been aquifer, lower, and upper confining. When it comes to pollution, pollution has been defined as something which is detrimental to physical, chemical, biological damage in the nature of water. And this has been clearly enshrined under Article 4, Clause D of the Federal Act. Wastewater, wastewater, and polluted wastewater, they have defined it separately. Polluted wastewater, as per Clause F of Section Article 4, means those wastewater which may pollute waters into which it flows. However, when it comes to wastewater, the definition is pretty lengthy. It basically means the water which has been altered by its properties, like altered by, domestic, industrial, commercial, agricultural, or any other uses, as well as that which flows with such water in sewers, precipitation water flowing off built up or sealed areas. They have also emphasized upon rehabilitation. Rehabilitation, basically, what they have done is they have emphasized on civil engineering. It's basically the re-establishment by means of civil engineering of the natural functions of channeled, straightened, covered, and culverted surface waters. Along with that, the permanent flow and residual flow has also been defined with respect to the flow rate of a water course. Other important factors which you will find under the Federal Water Protection Act of Switzerland are the prevention and remediation of detrimental effect. They have emphasized a lot on preventive measures as well as remediation measures, ensuring appropriate residual flow, prevention and remediation of other detrimental effects on waters, enforcement by confederation, financing incentives, procedural aspects, and criminal provisions. When it comes to this quality, maintaining the quality of the water, they have emphasized upon discharge, introduction, and infiltration of substances. The principle which basically guides is that prohibition is there to introduce any such things into the body of water, either directly or indirectly, which may pollute it, which may infiltrate it with such substances. Now, the thing is that it has been also prohibited to store and even spread such substances outside the body of water if there is a genuine risk of water pollution. So it is not necessary that it should only go to the water body. Even the outside of the water body, if you spray something or store something nearby that, which will have a potential risk, a genuine risk of water pollution, they have used the term genuine risk of water, subject to interpretation, that will also amount to discharge. Now, disposal of wastewater, they have emphasized that the polluted wastewater must be treated and it may only be discharged or infiltrated into a body of water with the authorization of the central authority. However, the non-polluted wastewater, it must be discharged by infiltration according to the instructions of the cantonal authorities. So cantons play a very significant role to understand and implement the local factors, keeping the local conditions in mind. In fact, if the local conditions do not permit this, such non-polluted water may be discharged into surface waters, and in case of any retention measures, it will be taken if possible so as to ensure that a steady discharge in the event of high inflow is there. And the discharge of this water that is not shown in the communal drainage plan approved by the canton, it should require the consent of the cantonal authority. So canton is responsible. In fact, they are also responsible to arrange drawing up of communal, if so required, regional drainage plans from time to time. There is something called Federal Council at the same point of time. The Federal Council is the chief, in fact, in the central level, which is responsible for adopting regulations with respect to discharge and infiltration of substances. It can enact, just the way we have under Environment Protection Act, the central government, which enacted adopt rules, regulations from time to time. So the Federal Council is responsible to enact regulations on discharge of wastewater, infiltration of wastewater, substances which may, according to the method of their use, enter into water by reason of their properties or by even quantities linked or risk polluting waters, impairing the operations. All these things are kind of pretty much there. Even with respect to treatment of wastewater, use of farm waters, they have emphasized on public sewerage, and there is something called central wastewater treatment plant. In fact, the cantons are responsible for construction of public sewers. They are also responsible for even building zones, existing groups of buildings, and there the central plants are responsible for ensuring treatment of polluted wastewater from building zones, from any existing group of building outside the building zones. So they have a zoning, and they will also ensure that these treatment plants are operated economically. They should be also in an isolated, sparsely inhabited region so that if something goes wrong, it will not affect people's health. And if any private sewers is there, which can also serve the public interest, their status is also equal to public sewerage. There is a duty also to connect the sewerage and to accept the polluted wastewater. In fact, the polluted wastewater which originates in the area served by the public sewers, it shall be discharged into such sewers. And when it comes to the areas that kind of been served by the public sewers, it includes this building zones and all those zones also which are outside the building zones. And the person who is responsible for this sewerage is, in fact, is obliged to accept the wastewater and convey it to the appropriate central waste water treatment plant. In addition to that, when it comes to animal husbandries, all animal husbandry farms, they too also have to, very nicely this have been done in their law, which I don't find in our legislation. In fact, with respect to animal husbandries, all these farms must attempt to balance the use of manure. And farm manure, which they are using in agriculture or horticulture purpose, they should be very much environmentally compatible. The farm must also have a very strong, good storage facilities with a capacity of at least 3 months. However, the cantonal authorities, they may also require high storage capacity from time to time for these establishments, and for that they have to go through that process. And they have clearly mentioned that maximum of 3 livestock units of manure may be spread to 1 hectare area of agricultural land if so required. The cantonal authorities are the one who are doing the major job. They shall also reduce the number of the livestock units of the manure permitted per hectares if the pollutant bearing capacity of the soil or the altitude or the topographical conditions demands so. Here, the Federal Council can also chip in because it may also authorize certain exemptions to the requirements for agricultural land in the cases, because agriculture is something, as I've mentioned a while back, contributes a lot to their GDP, and they are pretty much self-sufficient, and that's the reason the Federal Council may also authorize exemptions to the requirements for agricultural land in cases of poultry, horse stabling, farms, and for farms which in fact are serving public interest, say waste recovery, research, etc., etc. So they have something like that. Uh, with respect to inspection, installations, and equipments, they have a provision under Article 15, which clearly highlights the person who is responsible for wastewater treatment plants, storage facilities, technical processing plants for farm manure, or even for liquid digestate as well as of raw fodder silos, shall also ensure that these are used, serviced, and maintained in an appropriate manner from time to time. And Federal Council can also draw certain regulations on wastewater treatment. They can also draw regulations on lay down regulations on inspection and installations. They can lay down the requirements for, say, discharge into sewers or special releases or inspection of installations, etc., etc. So for that, the Federal Council can also adopt regulations from time to time as per Article 16 of the same. Uh, the thing is that when it comes to some other aspects relating to the water management, especially groundwater protection, they have something called groundwater zones. Now, groundwater protection zones is something where the cantons, they are responsible to determine protection zones for groundwater wells, the recharge installation serving the public interest. They shall also lay down any limitations on property rights which may be required to this effect. And the person who is responsible for these groundwater wells, they must carry out surveys which is required for establishment of boundaries of protection zones. uh, they can also the person who is responsible for groundwater wells are also responsible to bear the cost wherever is required for as compensation that is to be paid. And the groundwater, the cantons are also there to identify, determine groundwater protection areas. These are also there in our state groundwater legislations. In fact, Assam Groundwater Act 2012 goes something like that, a bit of it. But the thing is that the cantons in Switzerland, they are the one who will determine the areas which are of importance for future use for recharge of groundwater resources. They can designate a particular area as groundwater protection areas. That can be done under Article 21 of the federal law, Federal Act of Water Protection. When it comes to the handling of the liquids which may pollute water, there are certain general requirements that have been clearly specified under Article 22 of the same. Like, for example, the losses of liquids must be prevented at the storage installations, the transshipment areas, for example. When you have any person who is involved in manufacturing part for any installation, they must test whether these parts are corresponding to the states of art and the documents which might result in certain damage. So the thing is that there is a clear criteria as regards the same. In fact, for storage in man-made caverns, also the liquid which may pollute the water may not be stored in underground caverns. If they come into contact with groundwater, they may result in storage. So underwater caverns are something which are kind of not pretty much favored there. When it comes to soil use and the measures that apply to water, Article 27 of the Federal Act emphasizes on soil use. In fact, soil shall be used according to the state of art in such a way that the waters are not adversely affected in any way. In particular, avoiding both washing away and leaching of fertilizers. And the Federal Council once again may enact necessary regulation for soil use, measures which applies to water. Residual water is something which again is a major thing in Swiss water law. There is a permit mechanism. It's also kind of a command and control approach here. As per Article 29 of the Federal Act, there is a permit system which in fact required by any person whoever it is, who wish to withdraw water from a water course for permanent flow, or who wish to withdraw water from lakes or even groundwater resources which might affect the discharge rate of the water body from the permanent flow. So they have to get that. And there are certain conditions that have also been prescribed under Article 30, with respect to the permit. And if you refer to the minimal residual area, which is highly technical in nature, you have to refer to Article 31, which clearly specifies a minimum residual flow mandate with respect to the same. There are certain exemptions also at the same point of time, and it's the canton authorities which will decide with respect to low minimum residual. So these exemptions are with respect to the technicalities of the same, and they can in fact increase the minimum residual flow of the water at the same point of time. When it comes to water withdrawal from lakes and groundwater, if it is withdrawn from lakes or groundwater resources, then the rate of flow of the water resources, if it's thereby substantially affected, then the water courses in question must be protected by this particular act of Switzerland. And when it comes to remediation and prevention measures, there also they have something called the space provided for waters. Here what happened is that the cantons, after hearing the parties who are concerned, shall also stipulate a spatial requirement for surface waters. So there what they have done is in order to guarantee the nature functions of the water or flood protection or even use of the waters, from time to time the cantons as well as the federal council, they shall also regulate the details. Cantons are the one which will ensure that the space provided for water is taken into account in structure, land use planning, with respect to whether it's developed or exploited extensively. These things have to be taken care of by that. And they have also emphasized on artificial reinforcement and correction of water courses. In fact, water courses may be channeled and straightened only. Here, if you remember that MC Mehta Kamalnath case where the water course was diverted because of that motel. But when it comes to this artificial reinforcement, it's for the benefit of the watercourse, of course. So the watercourse may be channeled and straightened only in certain factors which they, like for example, if it's required for protection of persons or substantial, material values, if it is necessary for navigable purposes, if it's required for construction of landfills, if it's required for channeling and straightening to improve the water in a way, so water course in a way, in that kind of situation, such channelization, such artificial reinforcement and correction of water bodies are allowed. That is what it is. And when it comes to rehabilitation of waters, it is the cantons once again which shall ensure that the waters are rehabilitated. And in order to do so, they have to take into account the benefits of the nature and the landscape, as well as the economic consequences of the rehabilitation. And they are also responsible to plan the rehabilitation measure, to specify the time schedule for the same. So this is with respect to the same. Now, in addition to that, when it comes to groundwater, once again, Article 43 emphasizes that the cantons are the one who will ensure a long-term, no more water is withdrawn kind of approach from groundwater resources. Because if the groundwater is impaired as a result of excessive withdrawal, if it's through reduced recharge or something like that, then the canton shall ensure that the situation is remedied as far as possible, either through reducing the rate of withdrawal or by artificial recharge or underground storage of drinking water. So the thing is that, in a way, it is significantly responsible, and that is somewhere you will find the Swiss water law is quite effective in a way. They have something called bed load budget. This is basically the bed load budget in the body of water may not be changed by installations, but there are certain measures which can be taken with respect to the degree of harm that is caused to a body of a water, or ecological potential of the body of the water, or proportionality of the same, and so on and so forth. These are some of the factors with respect to extraction of sands and gravels, which are usually required for several other purposes. Anyone who wishes to extract gravels or sand or any such materials to carry out any excavations or something like that, they have to take permit. They have to take permit from the prescribed authority, and this prescribed authority will look into it. It may not be granted. Permits of such work may not be granted in the groundwater affected zones. So if you have if the cantons have already identified a particular area as a groundwater protected zone or area, then for that situation, for those areas, no extraction of gravel sand permit will be given. If it is below the groundwater table of groundwater resources, then also it will not be given. If it's for water courses where the bed load budget may be negatively affected, scientifically it has to be determined, then also it will not be permitted. So this is how it is. Along with that, there is something called the confederation. Now, the enforcement power of the confederation, which they have, the Federal Council, of course, they shall enact the implementing regulations. And with respect to confederation, they are the one to oversee the enforcement of the act. They have supervisory, and they also coordinate. And confederation, in fact, will oversee that, and Federal Council will regulate that. The coordination of all the water protection measures between federal agencies and cantons. So it has been done. It has to be done by the confederation, and they have the enforcement power as per Article 48 of it, which kind of prescribes that they shall enforce the regulations with respect to water, and they will also decide which information obtained in accordance with which federal acts and legislations from time to time. So that is something which is there with respect to that. They have certain special enforcement provisions also with respect to water protection agencies, water protection inspectorate. They have something called water protection inspectorate, basically inspect the qualities of the water and several other usage linked to that. So this is something, and they have also something called advisory services on fertilizers, and it will be the cantons which will ensure this advisory services must be set up for enforcement of this particular legislation. So forth. In fact, they have certain criminal elements also, which has been taken into consideration with respect to protecting the water, and incentives also, as I was mentioning, in order to promote, divert that the farmer should not use nitrate related products. So nitrogen removal in wastewater treatment plants, something for that they have this incentives under Article 61. And then there's a level of compensatory payment that has to be determined by the volume of nitrogen that is removed by mean of the ways that they are utilizing, the farmers are utilizing. In fact, removal of organic trace substance in the wastewater plant has also been considered under Article 61A, where compensatory payments have to be made if the construction or the procurement of any such installations or equipments or sewers have begun and they have used it for the purpose of removing of organic trace of substances in the wastewater plants that's there. Finally, when it comes to the criminal provisions under the federal law, well, they have prescribed some criminal provisions as regards the same, along with all these procedural norms. For that, you have to refer to Article 70 of that, where they have certain misdemeanors. The penalty shall be custodial sentence, which shall be up to 3 years, or a monetary penalty, which a person who willfully or unlawfully discharges into the water substances which may pollute the water directly or indirectly, or infiltrate or stores and spreads from outside waters and all. If he or in his or in her capacity as a person responsible for an installation which contains a liquid which may pollute the water, if they have not maintained the required water endowment laid down by the authorities, if they have unlawfully artificially reinforced or unlawfully corrected the water courses, if they have covered or culverts a water course without a permit or contrary to the condition that has been given in the permit, if they have introduced any solid substances in the lake, if they have extracted or undertaken any preparatory excavation without proper permissions as per Article 44. So if you fail to comply with Article 6, Article 22, 35, 37, 38, 39 and 44, you have 3 years imprisonment or a penalty. Which in fact for negligence also there is a penalty of fining, even for abetting and aiding this any offense. For them, the penalty shall be fine up to 20,000 francs. It's pretty huge. 20,000 francs for any person who willingly contravene this act, who contravene any individual order communicated to that individual, or in case of negligence. That is what it is. In fact, their criminal code has been applied. They have a Swiss criminal code, and as per Article 234 of Swiss criminal code, whoever violates this act also commits an offense under Article 234 of Swiss criminal act. So this is the beauty of it. So I do insist, please do refer to this federal act of water protection, federal law of water protection, as called the Federal Act of Switzerland, with respect to water protection law. Please do refer to the same. It's very interesting read, and it gives a very wider ambit. And there is a latest changes also that made in this year only on 20. In fact, it was initially in 1991, this particular law, and they have around more than 70 articles, and it's pretty much covering wide areas as regards to water pollution. So please refer to this, and I believe in a way the comparative environmental law lectures are addressed in such a fashion so that I can relate something. You can relate, of course. I'm relating. You can also relate the Indian scenario and these other foreign countries' legal scenario with respect to environment protection. So this is all for the comparative pollution laws, specific reference to water protection law of Switzerland. Please do refer to that federal legislation, and take care of yourself, take care of your family, stay safe, stay home. Thank you very much.